In this lecture, we shall discuss judicial remedies, specifically the prerogative writ of Quo Warranto. Quo Warranto. Now, you would recall that in our previous lecture, we have discussed the prerogative writs that can be issued. We have discussed the remedy of certiorari and prohibition, and we have also discussed mandamus. Now, if you look at Article 141 of the 1992 Constitution of Ghana, it indicates that the High Court shall have supervisory jurisdiction over all lower courts and adjudicating bodies. And then under Article 161 of our 1992 Constitution, we are told that in the exercise of such supervisory jurisdiction, the orders that the High Court can issue include mandamus, it includes certiorari, it includes quo warranto, and it includes prohibition. So it is important for us to know what we mean by quo warranto. Quo warranto. Now, in its literal sense, quo warranto basically refers to or means by what warrants? By what warrants? It means that if a person is occupying a particular public office, and then you know or you have a reasonable basis for believing that the person has usurped a particular public office, he has no basis for occupying that particular public office, there is no legitimacy in that office that he's occupying, you can bring an application for the prerogative writ of quo warranto to be issued. And once it is issued against that particular person, that person must justify the reason why he's occupying that particular public office. He must justify the basis on which he's occupying that particular public office. That is what you call quo warranto. Quo warranto. So quo warranto essentially refers to by what warrant you have to occupy that office. But it is important to note that one essential requirement for the grant of quo warranto is that it lies only in respect of public offices. Public offices. It means that the office must be one which is of a public nature. It means that if a person is occupying a particular position as the proprietor of some private school somewhere, you cannot apply for quo warranto to be issued against that particular person because that office is not a public office. So before quo warranto will be granted, before it will be issued, then it must be issued in respect of a public office. That is when quo warranto can be issued. And another requirement is that there must be an actual usurpation of office, because the essence, the reason why you are bringing the application for quo warranto is that you are saying that somebody who is not supposed to be in a particular public office, he's not supposed to be exercising the powers available to a particular public office, has usurped and is exercising the powers of that particular public office. In that case, you can apply for quo warranto, and then it may be issued against that public office, because quo warranto is granted when there's a usurpation of a public office, and it will be issued to let the person come forward and show what warrants he has to occupy that particular public office. So it can only be issued against a public office, and there must be an actual usurpation of the office. And there's one case that I shall use to explain to you this whole prerogative writ of quo warranto and how it can lie against public officers. And it's a case of Ghann. Ghann is spelled Ghann, N for nice, Ghann, N for nice. Ghann versus Tamaklu and another. Ghann versus Tamaklu and another, reported in 1957 to West African Court of Appeals. And the brief facts of the case are as follows, as can be gathered from the head notes. That by the Ghana Constitution, Order in Council, 1957, Section 63, Ghana is divided into regions. And by Section 64 of a regional assembly, by 64, a regional assembly is required to be established for each region. By Section 85, subsection 1, the members of parliament representing electoral districts within a region are constituted as an interim regional assembly for that region. And by Section 85, subsection 2, the Speaker is required to convene a meeting of each interim assembly and to preside as chairman until the interim regional assembly has made rules for regulating its own procedure and appointed its own chairman. I'll take that portion again. And by Section 85, subsection 2, the Speaker is required to convene a meeting of each interim assembly and to preside as chairman until the interim regional assembly has made rules for regulating its own procedure and appointed its own chairman. These steps were duly taken in the Ashanti region, and in the course, the interim regional assembly appointed its own chairman, who took up the duties of his office. Now, the person who was appointed, however, was not a member of parliament and was thus not a member of the interim regional assembly, but was drawn from outside that body. Again, the person appointed, however, was not a member of parliament and was thus not a member of the interim regional assembly, but was drawn from outside that body. The plaintiff, who was a member of the party in opposition in the Ashanti Interim Regional Assembly, thereupon sought an injunction, or in the alternative, an issue of an information in the nature of Quo Warranto to restrain the first defendant from acting as chairman. Again, the plaintiff, who was a member of the party in opposition in the Ashanti Regional Assembly, thereupon sought an injunction, or in the alternative, the issue of an information in the nature of Quo Warranto to restrain the first defendant from acting as chairman. Now, we proceed to the holding of the case. It was held that the office of chairman of an interim regional assembly is an office of a public nature against which a writ of Quo Warranto could have issued. Again, the office of chairman of an interim regional assembly is an office of a public nature against which a writ of Quo Warranto could have issued. The office of chairman of an interim regional assembly is an office of a public nature against which a writ of Quo Warranto could have issued. Now, what does this mean? This case is letting us know that Quo Warranto can be issued against an office which is of a public nature, and then Quo Warranto can be issued against an office. That is why I gave a requirement that before Quo Warranto will be issued, the office in question must be one which is of a public nature. So it must be one which is of a public office or one is of a public nature. That is when we can issue the writ of Quo Warranto. But one question that has usually arisen is whether the office of chieftaincy is one which we can describe as one which is of a public nature, so that the writ of Quo Warranto can be issued against such offices. In other words, if a person has usurped the office of chieftaincy and is exercising the powers that are available to that particular office, can a person bring an application for the issuance of the prerogative writ of Quo Warranto to be issued against such an office. Now, even though there have been previous positions that have held that the institution of chieftaincy is of a public nature and therefore Quo Warranto can be issued against it, it appears that the prevailing position is that the office of chieftaincy is not of a public nature and therefore Quo Warranto cannot be issued against such an office. And on this, I refer you to the case of Republic versus High Courts Registrar, Kumasi, ex parte Yiadom the First. Yiadom is spelled Yiadom the First. Reported in 1984-86, two Ghana law reports. And over there, if you look at the holding one, it reads as follows, and I quote, that the trial judge was right in refusing the application for Quo Warranto because the office of a chief was not that kind of public office which could be subject to attack by way of information in the nature of Quo Warranto. Even though the office of a chief was guaranteed by the Constitution 1979, Article 177 Clause 1, the guarantee did not and could not turn what was a public office, what was a non-public office, into a public one. Even though the office of a chief was guaranteed by the Constitution 1979, Article 177 Clause 1, the guarantee did not and could not turn what was a non-public office into a public one. Meaning that in this case, they have taken the position that the institution of chieftaincy is not a public office and therefore the prerogative writ of Quo Warranto will not be issued against such an office. Again, the same position has been affirmed and also reapplied in the case of Inriwana Republic versus Fijoli. Now, Fijoli is spelled Fijoli and then a hyphen and then NA. Inriwana, the Republic versus Fijoli, now ex parte Yakubu and others, reported in 1987-88, one Ghana law report at page 180. When you read this case and you look at the holding 2, it reads as follows, and I quote, chieftaincy was not a public office, and so it was not subject to Quo Warranto in the nature of an injunction. Chieftaincy was not a public office, and so it was not subject to Quo Warranto in the nature of an injunction. And so this is what you realize in relation to Quo Warranto. That as we have said, Quo Warranto is a prerogative writ that will lie against a public office, and is going to lie against that public office for the purpose of commanding that person to come forward and produce the warrant he has to occupy that particular office. If he can't produce that warrant, then he will be restrained from exercising any power that is available to that particular public office. So if you have a person who is purporting to exercise some powers that are available to a particular public office, then we can bring an application against that person for the prerogative writ of Quo Warranto to be issued against that particular person. The prerogative writ of Quo Warranto to be issued against that particular person. So Quo Warranto can be issued against a particular person who has usurped a public office for the person to justify the warrant he has to occupy that particular public office. If the person cannot justify that particular warrant, then he's supposed to be restrained from exercising any powers available to that particular public office. He's supposed to be restrained from exercising any particular power that is available to that particular public office. He's supposed to be restrained. And so there must be a usurpation of an office, and that office must be one which is a public office or of a public nature. And remember from our authorities in the case of Republic versus High Court Registrar, Kumasi ex parte Yiadom the First, reported in 1984-86, 2 Ghana Law Report at page 606, holding 1, that the office of chieftaincy was not a public office which could be subject to the issuance of the writ of Quo Warranto, which has also been affirmed in the case of Eri Wana Republic versus Fijoli Na ex parte Yakubu and others, reported in 1987-88, 1 Ghana Law Report at page 180, that chieftaincy was not a public office and so was not subject to Quo Warranto in the nature of an injunction. And so this is where we shall draw the curtains on our discussion with respect to the prerogative writ of Quo Warranto. Remember that you can go for this under the High Court supervisory jurisdiction under Article 141 of the Constitution, which provides that the High Court has supervisory jurisdiction over all lower courts and adjudicating bodies. And remember, Article 161 of the Constitution has given an indication as to what powers can be exercised when you invoke the supervisory jurisdiction of the courts. And so this is where we shall draw the curtains on our discussion in relation to the prerogative writ of Quo Warranto. Thank you.